It's a pleasure to be here. I want to begin by thanking all those responsible for putting this program together. It is a first-class program. There are, as one can imagine, because of some of the things Bert said, the interest in this case, a lot of programs being held almost on a daily basis, if not weekly, on this subject. And I think the folks who put this together, the Law Review, the Symposium editors, and with Wiggin and Dana's sponsorship, deserve a lot of credit for putting together a first-class program, and I think one of the better ones on this topic. And so I will listen with great interest to Bert and others as they speak and see what other people think. Let me just say briefly, by way of background, that, and in the interest of full disclosure, as Bob, who I want to echo is also a good friend, and it's always good to see Bob, mentioned, my firm and I do represent Microsoft, and I am generally billed as a legal consultant to Microsoft. I'm not part of the trial team, but I have been in court probably 70% of the time that the trial has gone on, and essentially attempted to read all the transcripts when I haven't been there and the written testimony. So I have a pretty good idea, I don't want to say unlike others, but I have a pretty good idea of what's actually in the record. I think as those of you who approach this case do so, it's important to be careful in focusing on what is actually in the record as opposed to what is described by the press as being particularly exciting on a given day, or what some people may say in terms of summarizing the evidence. It's difficult, obviously, in a short period of time to summarize what the evidence is, because after all, it's been 6 months now that the evidence has gone in. And as I'll at least attempt to explain, and be happy to talk a little more about, if one actually focuses on the record, and one actually focuses on the legal standards that the government has to meet in order to carry its burden, the fact is that a prediction that Microsoft will lose is much like a prediction that Gonzaga will win the NCAA finals. I think it really fails to understand both where the law is and how the record has developed. To the extent, and this is the premise of what I want to say here this morning, to the extent that the government wins, and certainly that is, while I don't think the highest probability outcome here, there's always a probability that that can happen in any case. But for them to win, in effect, I think the legal standards that apply or that the courts have interpreted as applying under Section 2 will have to change. And in order for that change, or if that change comes about, I think it will significantly expand the role of the government intervening in markets. And to me, unlike apparently some other people, courts are part of the government. And to the extent that they are drawn increasingly into various disputes under the antitrust laws, you are increasing the role of government. Not to mention the fact that, as the folks who brought this case have said, they are hoping through this case to establish rules for the information industry. And Joel Klein, about a year ago, before the case was filed, went out to Silicon Valley and pretty much said that he hoped to establish this case and that other people in the industry ought to be aware that to the extent those rules are established, they too will have to live by it. So I suppose to the extent that small probability occurs and the government wins, the one pleasure that some of us can get out of this is watching people like Scott McNeely and other people in the industry, Steve Case, who agitated for this case, essentially being hoisted on their own petard. Because, frankly, in almost every one of the cases in the industry, one can argue that the companies are in a similar position to Microsoft in their niche and have engaged in very similar practices, in some cases much more blatant. I'll just give you a little example. One of the issues that has come up periodically in the case is whether or not a Microsoft official ever said at a meeting with Intel that Microsoft intended to, quote, cut off Netscape's air supply, close quote. So far, there's no documented evidence that that occurred. The individual who is alleged to have said it denies it. Other people who were at the meeting, except for one disgruntled Intel employee, said he didn't say it. And when Jim Barksdale got up on the stand and they asked him, have you ever heard the phrase, cut off one's air supply, Barksdale, the head of Netscape, had to say, well, yes, I have. Well, where did you hear that, Mr. Barksdale? He said, well, Larry Ellison of Oracle coined that phrase in talking about defeating one of his relational database competitors. And it sort of took on a currency out in Silicon Valley. And in fact, so you have this famous term, cut off their air supply, which it turns out Microsoft never said, but it was said by one of the companies that is the most vocal and active advocate for the case. And that is supposed to be a centerpiece of the government's evidence that Microsoft deserves to be bopped on the head. What I want to talk about briefly is, and then as somebody said, one of the things that we are expected to do here is not only speak for a few minutes, but also provide editable text. And so on that score, there will be more in editable form. But what I want to talk a little bit about is, first, are the appropriate standards to evaluate unilateral conduct. Because after all, what we are talking about here is the activities of an individual firm. And what makes the Microsoft case a little different, or at least one can say back to the future, something that really hasn't been around for about 15 to 20 years, is the fact that it is an attack basically on unilateral conduct. The antitrust laws, I think it is pretty clear in the courts today, are a statute that is designed, or a group of statutes that are designed to protect, promote, and maximize consumer welfare, which is essentially an economic concept and describes the notion of, you can define it in various ways, total efficiency, maximizing output, maximizing total surplus in the market, but essentially making the maximum number of goods with society's scarce resources. And the notion is, of course, that you do that can happen in two ways. In a static sense, you try to increase productive or technical efficiency, which is the cost of producing a given good, and you try to maximize allocative efficiency, which is to say, ideally, in order to maximize allocative efficiency, all prices in the market would be equal to marginal cost. And there would be no scarcity, at least no artificial scarcity. And it's really kind of that artificial scarcity or restriction of output that antitrust law is historically concerned about. But at least over the last 20 years, most of the focus of enforcement, most of the focus of the courts has been on horizontal agreements, agreements among competitors. And the reason for that is, I think, fairly simple. When you have competitors who otherwise would be slugging it out in the marketplace, reaching an agreement, you have a risk that, unless there are a number of other competitors out there or the agreement is structured correctly, a direct increase or enhancement of market power and therefore likelihood of decreasing output. But the reason, the other trend in this area in the courts is a recognition that simply because competitors have agreed, even if it may have or carry the threat of restricting output and raising price, it also may carry the benefit or the possibility of integrative efficiencies, increasing productive efficiency or technical efficiency. And so the courts, I think, have become a little better at identifying horizontal agreements and subjecting them to sound tests to evaluate their effect. And obviously horizontal agreements range from per se illegal conduct like price fixing, which is subject to criminal condemnation, to joint ventures, which are subject to the rule of reason, or what might probably best be called an ancillary restraints analysis, all the way to mergers, where it's pretty much a structural analysis that governs. But in all those cases, there is, to some extent, an implicit trade-off between the threat to allocative efficiency or output against the potential benefits of integrative efficiency. Unilateral conduct, on the other hand, is something that the courts understand they have to give wide berth to. And you can look at the Copperwell decision, which essentially eliminated the bathtub conspiracy theory that had prevailed before then. But there's an interesting discussion in that case by the Supreme Court of the distinction that the courts have drawn between joint conduct and unilateral conduct, and recognize why we give unilateral conduct such wide berth. And primarily the reason is that in order for a marketplace to work, in order for markets to work effectively, we need to have individual persons, and that includes firms, going out there and acting on their incentive to maximize profit. And that profit maximization incentive drives folks to increase innovation, drives folks to improve the quality of their products, drives folks to lower prices towards marginal cost. And the danger of trying to interfere with that process is, one, anytime the government intervenes in the market, whether it's the courts or executive branch agencies, they impose certain costs just by their very nature of acting, but they also may send bad signals to the marketplace and that sort of thing, and they may get it wrong. And so we want to be very careful before we have government institutions supplanting consumer decisions or marketplace decisions. Moreover, we do have a history that we can see back, if you go far enough, of Section 2 cases that probably did get some things wrong, that probably did condemn conduct because of its immediate or apparent effect on competitors. But in the fullness of time and in retrospect, we realize, in fact, stopped conduct that had held the promise for increasing output, making consumers better off. And as a result of that, over the last 20 to 25 years, the courts have developed what I think is a fairly sound approach to looking at the question of monopoly or monopolization under Section 2. And Section 2 really is, with the exception of the Robinson-Patman Act, the one statute that addresses unilateral conduct. And under that statute, essentially, you have to show that a plaintiff has to show that a defendant first has monopoly power or a dangerous probability of obtaining monopoly power. And monopoly power is defined as the power to raise price or exclude competition from the marketplace. And that definition, courts increasingly have recognized, is not simply limited or is not simply established through market share because of the if you will, imprecision of market definition and because of a variety of other factors that may affect monopoly power. But even if you can show that, as a plaintiff, that a defendant has monopoly power, that is not sufficient for the courts to intervene. The courts will not intervene on that basis alone. And the reason is that having encouraged people to go out and compete and succeed and maximize profits, as Learned Hand said in the Alcoa case, you can't really punish the winner, the person who does a good job of what we ask them to do. So the courts have created this distinction between lawful conduct that achieves or results in success, perhaps even monopoly, and illegal conduct, or what is known as willful monopolization. And that term willful is a little confusing. The best way to understand it, and the way the courts in the modern cases and most of the commentators refer to it, is exclusionary or predatory conduct, as opposed to luck, skill, or foresight. If a position in a marketplace, even if it's deemed to convey monopoly power on a defendant, is not unlawful if it is a result of luck, skill, or foresight. And so it is only a narrow, I would say, and I think the courts would say, group of conduct that a monopolist engages in that's illegal, and that's exclusionary or predatory conduct. And what is exclusionary or predatory conduct? It is conduct that has two elements. First, it, in effect, imposes costs. I think technically may be the best way to think of it. Imposes costs generally on competition, not just a competitor, but competition broadly, that may drive competition out of the market, that may increase the cost of competition staying in the market and competing, gaining access to consumers, that sort of thing. And two, this is the second element, that the conduct has no legitimate business justification. Okay? So what does that mean? That means that essentially we don't really do a balancing test. And let me just give you an example of predatory pricing where in some recent Supreme Court cases the court has clarified the doctrine. And it really, that has two elements that sort of translate these two factors into a test for predatory pricing. First, the prices have to be below some measure of cost. Okay? Now that's the question of whether or not there's a legitimate business justification, because normally, in fact, invariably, at least under economic theory, if you know what marginal cost is and you've truly incorporated all costs into the calculation and all sources of revenue, no rational profit maximizer charges prices that are below cost. And therefore, you can think of the below cost test as in some ways being an evaluation of whether or not this pricing conduct has some justification, is legitimate. But then the second aspect of the test that the court really articulated in the Brook Group case, but has also been in others, is the notion that there is a likelihood of recoupment. Because after all, in predatory pricing and all these other types of conduct, the threat is, again, restriction of output, raising prices to consumers. And if, under the circumstances of the market, it's impossible to imagine that after this conduct is over, the defendant would be able to raise prices and recoup its investment in predation, then there really is no exclusion or predation, no, in effect, driving competition at large out of the market, because competition will still be there, entry is still possible, and while there may be harm to individual competitors, there is no harm to competition. But you can go through each case, I would say, in recent years, and each type of conduct, and show that those two standards, the need to show that you've imposed costs or foreclosed competition from the market, and lack of business justification exists. And it's not a balancing test either, because it's impossible, frankly, to balance those two things. Conduct that may, in fact, make a product better, more attractive to consumers, may, in fact, make it more difficult for competitors to compete. But how do you trade that off? How do you say that, okay, it was a legitimate business justification to do that conduct, it did expand the defendant's output, but competitors were harmed, and therefore we're going to deny consumers some benefit in order to protect some element of competition. Courts generally have not done that and probably shouldn't. Finally, let me just say, in the standard, it is an objective standard. You can't look at the subjective intent of the individuals engaging in the conduct and draw any conclusions. Because, as I said, what we depend on is the profit-maximizing incentives or motivations of individual firms to fuel the economy. And that fuel is, in effect, provided by the notion that if I succeed, maybe I will be the only competitor in the market, and maybe I will be able to earn high rents for my good conduct. And if you look at individual competitors' motivations, the desire to crush a competitor, the desire to gain market share, is equally consistent with legitimate competition on the merits that has a justification as it is with any exclusionary conduct. And that's why, frankly, over the last 20 years, court after court has essentially rejected that evidence as being of really any relevance in a Section 2 claim. Now let me go to the Microsoft case. Essentially, there are, as Bert mentioned, 4 claims. One has to do with the so-called tie-in. The other has to do with the exclusive contracts. The third and fourth are the monopolization, attempted monopolization claim. But don't get confused, because the monopolization and attempted monopolization claims are largely based on the first 2 claims. The reason they brought a tie-in claim is, frankly, because they were hoping to get the benefit of a per se rule, and unlike what Bert said, even if the Court of Appeals decision applies, which I think it does, so that the government cannot prove that Internet functionality in Windows 98 and the underlying operating system are separate products, but rather are a single product, and therefore they can't prove a per se illegal tie-in, that doesn't mean that conduct of a computer company is beyond review under the antitrust laws. It simply means that the plaintiff has to prove this standard that I talked about, that competition is truly harmed and that there's no legitimate justification for the conduct. Under that standard, though, frankly, and the reason I believe the government brought it as a tie-in claim, they know they can't prevail. And again, when the Court of Appeals decision came out, their arguments for why Internet functionality and the underlying operating system are separate products pretty much got blown out of the water. And the evidence they provided in this case is indistinct, is identical to the arguments and the affidavits that they basically put in the consent decree case, and the arguments that the Court of Appeals rejected. So I think they probably, and most people I think would agree, they're going to have a real difficult time on that first claim. Second issue are the exclusive practices. Now it is true that Microsoft, by and large, has stopped doing those things. There are actually legitimate justifications for them. The practices were not exclusionary in the sense of Microsoft told ISPs, Internet service providers or Internet content providers, they couldn't distribute anybody else's software. It was simply exclusive distribution, that if you participated in certain programs with Microsoft, you had to promote only Microsoft's browsing solution. But again, if you look at whether or not it had any exclusionary impact, at a period from October of 96 to October of 97, when all these practices were in effect, Netscape's number of users increased from 40 million to 65 million. And from late 97 through early 99, Netscape was embarked on a program they called Netscape Everywhere to essentially distribute 150 million copies of their Internet software. And on the eve of the trial, the month before the trial, Netscape reported that 12.4 million computer users had downloaded Netscape's browser software, which was several times the number of copies of Windows 98 that were sold during the same period. So as a practical matter, it's hard to say that Netscape was excluded from the market. It is true that Microsoft was increasing its user base at a faster rate, so that by early 98, pretty much it had drawn even with Netscape in terms of users. But it had done that not through any contractual practices, but because it improved its product. It worked the old-fashioned way. As it went from IE 1.0 technologies to 2.0, and then really to 3.0 and 4.0, the technology got much better reviews. It was viewed as being more desirable to independent software vendors who wanted to make their software compatible with the Internet. And essentially, frankly, a lot of users who really were new to computing and to the Internet found it easier to use Microsoft's technology. And so again, it's simply a reflection of Microsoft getting its product out, getting it disseminated widely, but not in any way excluding Netscape from the marketplace. And I think the evidence is pretty clear on both of those counts, and the government's going to have a very difficult time. Finally, with respect to the broader claim, because what happened was that was essentially the complaint when we started off. The government said they were just attacking these contractual provisions, and it was a narrow case. But after the Court of Appeals decision, I believe after the evidence came in on discovery, they expanded their strategy. They expanded their case. They started bringing in, for example, the so-called June 21st, 1995 meeting between Netscape and Microsoft, where the government now claims Microsoft invited Netscape to divide the browser market. Again, without boring you, but I'd be happy to talk later about it, if you look at the one precedent that exists out there, United States versus American Airlines, the so-called Crandall case, for condemning an invitation to an agreement that doesn't actually result in an agreement. The standards are very high for a plaintiff to prove that, to carry its burden. At the very least, they have to show that there's an unequivocal invitation to a per se unlawful or unjustified agreement. And if you look at the June 21st meeting, it's very ambiguous as to what was going on. It involved Microsoft executives who were not in a position to bind the company and who, according to Jim Barksdale, never actually said, let's divide the market. And finally, it was in a context where Microsoft was, at Netscape's invitation, discussing a range of cooperation, standard setting, technology sharing, that essentially, if you were to condemn those sorts of discussions, you would pretty much dam up all of the discussions that are key to the kind of cooperation and interrelationships that prevail in Silicon Valley today and are necessary for the movement of the industry. Well, I don't have much time. I have a matter of seconds. I want to just say two things. First, with respect to remedies, I will listen attentively to what the speakers have to say, but I will make one comment, and that is that if you look at judicially imposed structural relief, the last time a court, to my knowledge, but maybe Bill can correct me, the last time a court imposed such relief was in the late 60s. It is true that AT&T agreed to relief in the early 80s, but that was a very unique case, and frankly AT&T wanted it because they were concerned about continuation of having regulators use their long-distance revenues to subsidize local telephone companies and local, local telephone consumers. And so from their perspective, it made business sense. But it's very unusual for courts to impose the remedy. With perhaps one exception, the remedy is only imposed in cases where, essentially like in Standard Oil, you have the conglomeration of previously separate companies and you have the spinoff of their stock. It has never, there might be one exception to what I'm about to say, but even that exception does not establish that it's viable. A case where a court has gone in and taken a company that is really an indivisible whole and tried to break it up. So I think a lot of the remedies that are being discussed that are rather extreme, one, are inconsistent with what the government asked for in its complaint and originally proposed, and two, are sufficiently radical in terms of a precedent that I don't think at the end of the day will prevail. And then finally, let me just reiterate what I said at the outset about what is at stake. I think that in order for the government to prevail, they really are going to have to sort of reduce their burden for showing that there's actual harm to competition or harm to consumer welfare. They haven't really been able in the case to put in any evidence on that. Second, I think they're going to have to get a court to agree to raise the bar in terms of what a company shows for legitimate business justification. And finally, I think they're going to have to get a court to ignore some of the learning over the last 20 years about a more fulsome approach to the question of market power and monopoly power and the things that are relevant in evaluating it. And I think if they succeed, then not only will it have serious and I believe adverse effects on this industry, but it frankly will open up a new vista for enforcement opportunities for plaintiff actions, which is good for me as an antitrust lawyer and good for any of you out there who are aspiring antitrust lawyers. But in that great wider world that's out there, I think it's probably bad news for consumers and bad news for the economy. Thank you.